Good evening and welcome to Law Talk. This is the show that brings the Constitution, the events of the day, and the law to you each month. And tonight, myself, James Barrett, and Mark Malachowski are coming to you in a little different format, and that's due to the shelter in place under the COVID-19. But there's other things we have to worry about with COVID-19. And Mark and I see it daily. And those are our business clients. Our business clients are facing untold financial misery. And tonight, Mark is going to lead off and tell us a little bit of solutions and potential help that a good law firm can give a business that's suffering financially. Mark, take it away.
Okay, well, we have an unprecedented situation here with the COVID-19 and then the shutdowns. There's been government shutdowns. And, I think it was right around April 27th or so, everyone thought, okay, May 4th, everyone's going to go back to work. And then right around April 27th, 28th, it was like, no, it's going to be June 1st. And people are wondering, well, what if on May 27th, they say it's July 1st and then August 1st and September 1st? Who knows really when your business is going to be able to open again? And I think the people that are particularly hard hit are restaurants, because you have people seated together, gyms because you have people working out together, nail salons, barbers, hairdressers, that kind of thing.
Bars.
So bars are badly hit.
Oh,
so
my God, bars. San Francisco is under assault right now because of this.
And so, that's going to be really tough on these business owners. And you've got to understand, a lot of restaurant owners in San Francisco or even throughout the whole Bay Area may be spending $20,000 or $30,000 a month as a lease. If they have several restaurants, maybe they've got 3 or 4 year leases. You're talking about millions of dollars of liability they have, and are they going to be able to pay those leases? Also, they've got payroll. They could have a couple $300,000 a month in payroll every month.
Well, you know what happens with that, Mark? The government's been trying to help, but the money's just not flowing enough to those small businesses. So what are the solutions, Mark?
Well, one thing that there have been some, different government funding sources, but they dried up pretty quickly. And, so most folks couldn't avail themselves to that. Now, the thing about this is that people have to understand is that, if your business is in big trouble, for reasons and circumstances beyond your control, we have to realize there is a way that we can go to the federal government and look for relief with the federal government.
And what is that, Mark?
Well, there are several kinds of relief, but for businesses, it would be what they call Chapter 11. And what Chapter 11 does is a restructuring of your business. So you may have a mountain of debt right now for the couple of months that you weren't running and you're building up this debt. If you go to and do a plan, that debt to a certain extent would be forgiven and then paid off on a percentage basis, and a whole plan put together to move your business forward.
Well, Mark, I have some. I know that the people generally are accustomed with maybe hearing about Chapter 7, which is a complete bankruptcy. How is a Chapter 11 different than a Chapter 7?
Well, in a Chapter 7, your debts are completely wiped out, right? And you get to keep a couple of things. You can keep maybe $140,000 in your home. There's some things you can keep. But in a Chapter 11, it's for a business entity. So this is going to be for corporations and LLCs generally. In some cases, it would be sole proprietorships, but mostly it'd be corporate and LLCs. And in California, LLCs are actually a form of corporations anyway. So these are entities that can survive, but they go through the Chapter 11 process. And what will happen is there's going to be a trustee that's going to look at all the assets, look at all your arrears, look at all your debts, and then you basically become a debtor in possession, what property you own, and that what you need to sell to pay off a percentage of your debt to satisfy some of your creditors that you're in arrears to. But it would be usually a small percentage, 5 or 10% or something like that.
Well, I have a question. If you have assets and you want to keep your business running, will the court let you keep your business running during your Chapter 11 process?
Well, there's different types of assets. If you have a business asset, they would take a look at those, right? And you might have to sell some of those business assets. Hopefully, that you have a corporation or an LLC, and you'd have a corporate veil, and that would protect your home.
Well, I have a question on that also, because wouldn't you want to continue to operate with using your vendors and maybe your institutional investors? Don't you want to continue to use those relationships to help support your company?
Well, that's one of the issues that does crop up. Some folks are very upset when you go through a process where you have a plan. Some of these are kind of prepared plans, and some of them are a little more customized. But then there comes the day when they call it the cram down, and what that means is that the plan is kind of crammed down the throat of the person that the money is owed to, right? And so they're not always very happy about taking a certain percentage on their dollar. And some take it personally, and they won't do business with you anymore, and that happens. And others see it as, okay, we just went through a process, and it's a legal process. But there is a certain amount of risk of losing some of your vendors if you don't pay them the full amount and you put them through the process. That's true.
Well, can I use an example right now? I actually had a client come to me, and they were a creditor against a major technology firm that's still in the process, and I can't name that firm, but they have millions of dollars of proprietary licensing and assets, multiple buildings, lots of stuff, so to speak, let alone the proprietary value. They have institutional investors. Now, the downside was this. My client was basically was owed about $90,000 due to providing services to the company. But as it turns out, there's a lot of companies in that ballpark that were owed 100,000, 50,000, 200,000, let alone the institutional investors who had put millions into the company. But the company has one of the leading proprietary licensing products, and actually multiple products that are cutting edge. So they have this huge value. And what they've done is a strategic Chapter 11, whereby they wanted to hold off the institutional investors who forced the bankruptcy under 11. But all the little guys are going to potentially be in the position you're describing when the institutional secured investors are going to be walking away after they force this. So how do you protect the unsecured investors?
Well, unsecured investors or unsecured creditors are taking a risk. Creditors are taking a risk. And anytime you're in that situation, you're taking a risk. And going through the Chapter 11 process, the unsecured creditors are probably not going to be happy with the outcome.
So unsecured creditors are going to take it, even though there's a reorganization going with millions of dollars of assets. Even at that point, the unsecured creditors are going to have some issues.
Well, I think that's a case-by-case basis, and it's up to the trustee. And the trustee looks at these situations pretty carefully. And there's a process to go through. They're going to look at what you see, looking at your assets for the debtor in possession, look at your arrearages, look at your liabilities. It's going to be a whole process that they're going to have to go through. And if you do have an entity like you're talking about that's able to kind of influence the direction of who gets paid off and who doesn't, that can happen. But your unsecured creditors are face you some issues there. There's no doubt about it.
Well, I will inform you that in this case, the bankruptcy trustee is actually putting together a committee for the unsecured creditors. It's called an unsecured creditor committee.
Right.
And everything that's going on in the bankruptcy is monitored by the committee, because the goal is to get back as much as possible for the unsecured creditors And this is kind of, there's a little fight going on between the secured creditors and the unsecured creditors, because the bankruptcy trustee and a judge are overseeing this. And interestingly enough, they're both looking out kind of for the little guy. And so the question is, how much do you know that the court and the bankruptcy trustee will put the debtor through to ensure that some of the unsecured creditors are actually made as whole as possible?
Well, I think that the cases I've worked on in bankruptcy, it's usually the bankruptcy judges and the trustees. Now, I don't know for, I'm saying if you end up in an adversarial proceeding or something like that, you've got some judges with a lot of experience, and they've seen a lot of these financial plans go through. And I would say it's unlikely you're going to be able to pull the wool over a judge's eyes in the bankruptcy court.
So you believe that they're going to be forced to actually put together, because the issue about, because there's assets in the millions and millions of dollars, I don't know what level the judge is going to go or the trustee's going to go, but it seems as though that there's a big push, because you can't just have a company that's that viable just decide to wipe out all the unsecured debt.
Well, yeah, there's going to be cases that are going to be hard fought. There's no doubt about it. You're going to have other cases, like say for someone, like for example, if a restaurant's leasing, right, and they have a lot of payroll and they have a lot of perishable goods, and they're not going to have a lot of assets, really, right? Those are going to be a little more straightforward than what you're talking about. What you're talking about is what can we carry asset-wise through the Chapter 11. And that gets into the plan, and that's not going to be a prepared plan or a standard plan or a canned plan. That's going to be a customized plan, and that's going to be a hard-fought battle every inch of the way of exactly how the plan is put together and how it's executed and the timings and that kind of thing. In other words, how many years are people going to get paid off? What amounts are they going to get paid off? And how do you align the creditors as far as a triage or as priority?
Well, I have a question. What would a creditor be, an unsecured creditor, be looking at? How many years do they have to pay off in these plans?
Well, these plans vary, but it could be several years, right?
Several years.
Yeah, it could be several years. So, it could go over a period of time, or they could take, pretty much a cash out at and a one-shot payout too. So I think that's the plan. And when you're doing a customized plan, I think it can go a lot of different directions.
Okay, so I'm not going to use that example. I'm going to go back to what's happening in San Francisco, restaurants and bars. They carry a payroll that go month to month, in their balance books, right? And the balance of their books. So what would that look like? Say I owned a bar that's in a very frequented bar. It's been in business for 10 years. Its payroll could easily be 30,000 a month or whatever.
Probably more than that.
Even 50,000 a month.
Right.
And they're fortunately it's a bar, so there's not a lot of food that's perishable. But you have the problem of your lease, because you're leased because you could be in a Sunset District or some district downtown, right off Market. You could be in Embarcadero. What do you tell your landlord? And how do you structure a plan that will satisfy a landlord who actually owns the business, the building you're in? How do you work that?
Well, that's an issue that's coming up with mortgages and leases, and either the bank or the landlord is looking at, well, if I evict this person, who's going to take their place? So to that degree, there's a certain balance point of like, well, if I foreclose on this property, or if I evict from this lease, who's going to come in? Because there's a certain amount of uncertainty. So there's a lot of negotiation there that would take place probably before the bankruptcy is even filed. And of course, when you're in this kind of situation, many times there's lawsuits in the state superior court prior to someone filing bankruptcy, right? And we can do that work too. And a lot of that is, sometimes negotiation and arbitration to try to work out these kind of payments plans. But if it can't be worked out, then you would go and seek relief from the federal government. But
What
you've
I'm
got to
concerned
understand
about,
these
Mark, is
landlords
we're
and
in
banks.
unique times, Mark.
What's
These
that?
Very unique times.
But I'm saying these landlords and banks are not in a great position either, because if they evict somebody, for one thing, anytime you change businesses, they're going to want to rip out refrigerators and walls and lighting, and that's going to take a month or two. And then anytime you're signing a new lease, that's another thing. And then in the uncertain business climate of, how are you going to run a restaurant if you've got a plastic sheet between you and the person you're talking to and you're wearing a mask? I don't know if that's your romantic evening you were hoping for. So, or how close you can have the tables. There's all kinds of unanswered questions. So who's going to fill that space, which is, kind of historically been, a restaurant space. So I think there's a lot of negotiation. There's going to be a lot of state superior court work first in many cases before you go up to the bankruptcy court.
So
In other cases, it might be.
With you, Mark. Let me
What's that?
speculate. So there may be, doesn't this sort of demand a changing approach for us in litigation on how we're going to really think about what's going on? Because I know you represent landlords. I represent both landlords and tenants and wide variety of commercial businesses. But the issue that I see, there's a change that's going to have to come around because the judges are going to be going, well, you couldn't pay your lease, but we had COVID-19 for 4 months. And I just see there's going to be kind of a little more forced mediation with more certainty in the mediation coming up. I see a lot of judges, they're going to be making decisions based on COVID-19 a little bit. And I'm just curious, what do you speculate is going to happen in the court system with all of this acts of God kind of litigation?
Well, I have a hearing on Monday in Law in Motion.
On Monday?
Yeah, on motion, Law in Motion. It's on the calendar. I mean, I have to go. I'll be there at 9:00. But if I was talking to opposing counsel and we were talking about other dates and, we had a meet and confer today. And I said, well, maybe we can move this into June and all that kind of, we agreed on a date, just like the judge's order said, get together and agree on, future dates. And we did all our meet and confer. We agreed, okay, you agree on this email. I sent the email in and I got a response from the Superior Court that, we're not responding to anything. We're not doing anything. We're shut down. So, I mean,
You're not going.
Well, I'm going to go there Monday anyway, because I'm going to go. But it is on calendar. So I think there's going to be a fair amount of confusion because and then even once things open up, there's going to be a deluge of court cases that they're trying to put in these times. And I think probably you're exactly right. Judges are going to try and see if they can do some mediation and arbitration to ease off of the kind of stampede or deluge of all these court cases hitting at once, because there's only so many courtrooms right now. 75% of the courtrooms are shut down. Most of the clerks are gone. And, for at this moment, if you have a domestic violence, if you have child custody, you're probably going to have a court date. If you have a felony arraignment, you're probably going to have a court date.
Well, if you're in jail, you're going to have a court date.
Yeah, that's a felony arraignment or whatever. Yeah. So, but I'm just saying, other than that, these court cases are pushed out quite a bit, and nobody really knows how like I said, the triage of cases is going to work out. But there's a certain amount of confusion right now, and because the calendars are still up, they haven't been changed, and they don't say we're vacated, right? You still have a court date, but apparently you can't really communicate that well. So I think there's going to be a lot of confusion.
Let's take us back then to Chapter 11. How are the federal courts handling this if all these courts are closed?
Well, I think the federal courts are in a better position to work than the Superior Court because there's just less cases. And also the federal court cases tend to be a bit more sophisticated. The attorneys are working at a slightly higher level and the judges are working at a higher level. And it takes longer for these cases to mature. And a lot of it, and also the federal courts have been doing electronic filing I've been doing electronic filings. I remember when it was AOL, when you're watching the document load with the little, the little bar moving across the screen kind of thing. And so the federal courts have been doing, e-filing in its own fashion for many years before the Superior Courts.
Well, can I add something? Let me add something, Mark. Besides the electronic filing, I actually sat in a week ago on a federal bankruptcy, and the judge, they had everybody that was a party on talking. It's like not necessarily Zoom video, but
Right.
they had the people attending all by, it's like court call sort of.
Right.
Run through the federal court system. So this is a new court call just for the federal court system.
And another thing, when you're
adapting, but I'm not clear how that's going to work, because we have court call in our superior courts, but that process is just not robust at all.
Well, let me give you an example. In federal court, when I'm in, like say if I'm in federal court in an adversarial proceeding, I'm being tape recorded.
Yep.
Everything I say, and I can go back to my office and half hour afterwards, or probably 10 minutes afterwards, and I can hear every word I said and the other counsel said and all the witnesses said. So the federal courts are, I think, quite a bit ahead of the superior courts as far as doing electronics. Now, I haven't done a lot of videotaping in federal court, but there's the audio taping has been going on for a long time, and so it's also it's a different environment. There's less people in the halls. You go to superior court, you have a jury trial in superior court, and there's hundreds of people in the halls, and judges, I wasn't going to use that term, but judges are going, well, Mr. Malachowski, we can't give you a jury for, there's no way we can't give you a jury. We'll put you out, whatever amount of time you need to go, or you can agree with, but there's more cases than the court can handle, and it's a different situation. And I think a lot of the things the courts are worried about are people waiting in the halls, right?
Well, that's, if you're talking about shelter in place, that sure is not a good idea to have the jury pool standing there coughing and gagging in the hallway.
But I'm just saying, you go to a superior court any day, like law and motion morning or something, and it's, there's people in the halls. Even in the courtroom, you might say, okay, we can have some separation. But you go out in the hallway, there's not separation. There's people all over the place.
Right.
It's very crowded. You don't see that as much in the federal court. The paperwork is a lot more complicated. Like I said, the cases are a bit more sophisticated. Things move at a different level. Lawyers are expected to move federal cases along without case management conferences and prodding from the judges, because you'll get something from the judge, like an OSC, an order to show cause, is like, what are you doing here? You're supposed to be prosecuting this case. So it's not like, it's not like you have a CMC, a case management conference, where the judge goes, well, what have you been doing lately? It's not that kind of folksy, friendly thing in superior court. It's like, you're a lawyer, you're in federal court, you're supposed to be prosecuting.
No, and the judges in federal court, they treat you like adults. And if you're not acting like an adult, I have to tell you that we're all subject to sometimes delay and
right.
And so state court kind of allows, they coddle you along a little more. Federal courts, there's no coddling.
No, but also in the federal courts, the judge is like, well, what have you guys stipulated to, right? What have you stipulated, and what do you want to fight about, right? They want to know, like, did you guys have a meet and confer and figure it out what were actually the battle points here?
Right.
Out of the 30 things in your pleading here, what are the 5 you want to fight for? And I want to know what those are, and those got to be signed. And
I want to know all the witnesses. I want to know everything you're involved with. No fooling around.
And even, and also even federal judges I've had federal judges. I had a case where we were in litigation against Verizon, right, which is a pretty big company. And, we were all ready with our briefs and everything. We're all ready for the hearing. The hearing's Monday. And on Friday, right, instead of like a tentative ruling, the judge says, here's a case that I like better than any of the cases you cited. Be ready to argue this one. So everything you've ever given us, I don't care about, both sides, here's the case I want you guys to argue. And so it's like, it's Friday night, it's Saturday and Sunday, we got to read this case and be ready to argue it orally. So, you have to be a little bit more on your toes. on a federal case, and you don't get weekends off when you're in the middle of trial.
No, there's no
There's no
weekends
weekends.
off in federal cases. No, thank God.
So, I mean, it's a
I know,
different
you're
world.
supposed to relax, right?
Yeah, but I mean, it's a different world. Federal cases move with a certain type of efficiency, and they expect the lawyers to move things along. And I think that's the reason that there's going to be
Well,
more things happening.
that's a segue. I'm gonna ask you about a different subject here, and we're gonna kind of wind up this month's show. But I want to talk about briefly the Michael Flynn case. Have you been following the Michael Flynn case?
Well, the Michael Flynn case is kind of interesting because he did make a plea deal. And so, yeah, he pled guilty. And so some people would call that confession. And I think anytime you make a plea deal, there's and this is going out of bankruptcy and talking about criminal law, because they accused him of lying to the FBI, which I think is a 1,000 or something like that, which is a big deal. It's a year in jail to lie to the FBI. And in fact, I think we did a show once on the whale watchers, who someone whistled at a whale, and then they said, no, I never whistled at a whale. And one of the tourists was taking a videotape, and this lady who loved whales and her whole life was taking tourists out to see whales, she got they're going to put her in jail for a year for lying about whistling at a whale. And so lying to the FBI is a serious thing. Now, as always, the best thing to say to any officer, whether it's the FBI or the police, is I want to talk to my attorney.
I want to have my attorney present. I
want to talk to my attorney. That's what you want to say, and there's nothing wrong with that. It's not an admission of guilt, and it's just I want to talk to my attorney.
Mark, can I tell you something? That takes us back to our first show we've ever done 9 years ago. Don't talk to the cops.
Well, the point of the matter is, the FBI comes into Flynn. Flynn is part of the executive branch. He has a presidential attorney or executive office attorney.
That's available.
He's supposed to say, look, you'll have to talk to you're in police, you have to talk to my attorney.
Right.
And so, there is so there's a little bit like, well, was that fair? Was that legal to entrap Flynn in that way? Was that really entrapment? I would say that, you should beware that if you talk to a police officer, that you should have your attorney present at all times.
Correct.
And it doesn't matter if you've committed a crime or not.
No.
Because, sometimes things could be construed to be a little bit different than you thought. Now, what was interesting about the Flynn case is there was some allegations, and I haven't read the whole case. There were some allegations that the prosecutor said they were going to do something to Flynn's son.
Okay, let me fill that part in. The idea was either you're going to plead guilty or we're going to prosecute your son for some odd, and see, this is what's left out a lot of the news, but they said we're going to go after your son. Not that they had a crime on the son, just that they were going to go after, because they already ruined Flynn. He went bankrupt. Had to sell everything he owned.
Oh, that's a good question. Did Flynn do a chapter 7 or he do a 13? Because
he did a chapter 7 because he lost.
Okay, well, that's one thing we didn't talk about. For a personal bankruptcy, there's a 7, that's you wipe the slate clean, and there's a 13 that's almost like a reorganization. That's like an 11.
Yeah, it's like an 11.
He did a 7.
Business is 11, individuals 13. But what I was going to say was the Flynn case we're going to cover, because right now, Emmett Sullivan, the judge, was handed a motion by the Department of Justice, who said, we're dropping this case. That means you sign this, Your Honor. That's our motion. We're dropping everything. Flynn walks. Now, he doesn't go scot-free, by our former president said, because scot-free would mean he had no consequences. Unfortunately, he had a lot of consequences. But Emmett Sullivan went, and by the way, you can only imagine who he voted for, wasn't Trump. But the fact of the matter is, he said, no, I'm not going to accept this motion as is. I'm requesting briefing from friends of the court. And there's only going to be one gang of friends of the court that write a lot of briefs against this. And so now he's kind of changed the whole dynamic of the DOJ dropping the case.
Well, I think what you're talking about there, because one thing I really enjoyed when I was studying law was reading the Louisiana cases, right? is they have Napoleonic law, which is
Right.
basically the judge is the jury and the prosecutor. And I think this Judge Sullivan is practicing that kind of Louisiana law, and it's very colorful law. And it's basically, they're like, well, we'll hang them, and the ones that live were if you live through the hanging, you were innocent, but if you die, you were guilty, kind of thing. So,
Well, wait a minute. Yeah, if you made it, that means the Lord's on your side.
yeah, right. Well, it's it's Napoleonic law. What did Napoleon said? He says there's so many laws. I'm surprised everyone hasn't been hung. So has not been hanged. So I'm never sure what the past tense of hung. But yeah, Napoleon says there's so many laws. I'm surprised they haven't hung everybody. And but here's my Napoleon joke that I think would go.
Well, that'll be good. We can end it on the Napoleon joke.
Okay. So anyway, so this guy's getting his head cut off, right? It's the Jacobsons, the revolutionaries, and they're chopping off people's heads with the guillotine. And this Catholic priest comes up there, and they're going to chop off his head, and he goes, "Do you mind if I face heaven before I go, so I can see my Creator when I get my head chopped off?" And they go, "You can lay down any way you want." So instead of like most people laying on his stomach,
Yeah.
he lays on his back. They pull the cord, and the guillotine comes down, and the blade stops an inch from his neck. And everyone goes, "Oh my gosh, it's America! Well, he's a man of God. We've got to set him free." And then, hey, yeah, let him go. The next guy comes up. He's a rabbi, and he says, "I'm a man of God too, and I'm going to face heaven on my way out. So I want to do the same thing." He lays down. They pull the cord. The blade comes down an inch from the rabbi's neck. It stops. Like, "Oh my gosh, another man of God. We must let him go." So they set him free. The next guy comes up as an engineer, and he goes, "Well, statistically speaking, the last two people who laid face up, all lived. And so the odds are that if I lay face up, I'll have a better chance of surviving. So based on the scientific method, I'm going to lay down as well." And they said, "You can go anywhere you want." So he lays down, and right before the guy pulls the cord, he goes, "I see what's wrong."
Well, listen, on that happy note, I think we're going to sign off of Law Talk for the month of May 2020. But Mark, I wanted to thank you, and I want to thank our crew for putting together an excellent show during difficult times. And next month, we'll come back with more excitement in the world of the law, the Constitution, and the events of today. Hey, thanks, Mark.
Okay, good night, Jim.
And I'll see you next time.
See you next time.